Hello, everyone, and welcome to another live edition of Employment Law Q&A. Welcome, everyone. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru, Tumarkin, LLP. We are the employment lawyers coming to you today from a snowy Ottawa, Ontario. You can see the background, some snow on the ground there. We're well into the winter season, for better or worse. Welcome. This is your opportunity to chat with an employment lawyer. We, of course, do these live Q&As a few times a week, and it's your chance to get your questions answered. If you're having a hard time at work, perhaps your boss is mistreating you, perhaps you've been let go from your employment, maybe you're dealing with a change to your terms of employment, maybe your employer is asking you to accept a different position, perhaps accept a different pay structure, or accept a demotion or a pay reduction. Any one of those issues, if you're dealing with a difficult situation at work, if you're having a hard time with your employer, now is your chance to go ahead and ask that question. Go ahead and seek that advice from an employment lawyer, such as myself, in order to get your way to resolving that kind of workplace problems. When you're dealing with a difficult situation at work, oftentimes these situations fester. They become more difficult, more complicated, the longer you let them lag. And so if you're dealing with one of those situations at work, do not just, put it in the desk drawer hoping that it goes away. You need to deal with a difficult situation right away. You need advice. You need to know what your rights are, what your options are in any given situation. And again, oftentimes the longer you let that problem linger, the more difficult, the more complicated it becomes. So please, if you're dealing with a difficult situation at work, or certainly if you've been let go from your job, maybe you've been offered a severance package, maybe you haven't been offered any severance whatsoever, it's your obligation to speak with an employment lawyer right away. Go ahead and post your question right now online. Keep it confidential. You don't have to mention your employer's name. You don't have to go into any individual particular details about your personal circumstances. Ask the question in a very general way, and I promise I will answer it. Not only will I answer it, but certainly we could set up a time to chat outside of a live stream to perhaps get into that more detail about the particular situation. Please reach out. We're here to help. We're here to answer questions and resolve those kinds of workplace problems. As well, if you're dealing with a medical leave of absence at work, maybe you're dealing with a disability benefits issue. Maybe you have short-term or long-term disability benefits coverage through your employer, and you're having a hard time there. Maybe the insurance company is giving you a hard time. Maybe you're trying to get back to work, but your employer isn't allowing you to return back from a medical leave. We answer those kinds of questions as well. We deal with disability insurance. We deal with medical leaves of absence all the time. Go ahead and ask your question related to that as well. You can also visit our website, disabilityrights.ca. You can see it on the screen right now, or you can send us an email, help@disabilityrights.ca as well. Now, speaking of that, let's give you our contact information here so that we can get in touch off live stream, off air, so to speak. Oftentimes, these kinds of matters require an in-depth conversation. Do not be shy to reach out to us. The initial contact with our intake team is absolutely free. You can give us a call at the office, speak to somebody right away, get the basics of your situation, and get you pointed in the right direction, get you a call scheduled with a lawyer. Our website, employmentlawyer.ca, is where you should start. Go ahead and punch it in right now if you're curious. Employmentlawyer.ca. It is our website. We've got, of course, our phone number there and our individual contact information for our lawyers there. We also have a ton of resources on our website. If you have no idea where to start when it comes to either severance or changes to your employment, maybe you've been temporarily laid off from your employment, go ahead and visit our website. You can go to blogs or news articles, and I guarantee you will find something on the particular issue that you're dealing with. It's a great website for really that reason. We've got a ton of resources there, video clips, news articles, etc. On those issues. You can also email us if you want to get in touch with us. The email address is help@employmentlawyer.ca. That's help@employmentlawyer.ca. Send us an email. Don't send us a 10-page email. Send us an email with a couple of paragraphs, a couple of sentences, kind of generally about your situation. Give us the broad strokes, and I promise someone will get back to you and get back to that email. We answer a ton of emails at that email address every single a day. And do not be shy to email us at that email address. There's no cost, certainly. So, and of course, if you want to get a hold of us, by giving us a call, the old school way, that's absolutely fine as well. As I mentioned before, we've got a ton of resources, of kind of intake team members that are there to field questions, field telephone calls, and again, get you pointed in the right direction. Our telephone number is right on our screen right now if you want to make a note of us. Again, don't be shy to give us a call. There's no commitment. There's no initial fee. Don't be shy to reach out. Again, if you're having a situation at work, whether that's employment related, whether that's disability insurance related, we are here to help in either one of those respects. I already see some questions being lined up. B on Facebook. Where we are, Sir S, Roland, Jason, thank you so much, all of you, for your questions. For those of you just tuning in, this is a live employment law and disability insurance law Q&A, question and answer session. I'm not here to rant and rave about employment law. I am here to answer questions. So if you're just curious about a situation, maybe you want to know what your severance entitlements are, give me your age, position, and years of service with the company. Happy to answer that. If you're dealing with a bit of a different issue at work, maybe you're dealing with, an angry boss, a boss that's mistreating you. Maybe your employer is going through some changes and you're worried about your position. Go ahead and post your question right now. I promise I will get to it before the end of the segment. And I guarantee you, by asking your question, not only will you be helping yourself, and you will absolutely be helping yourself, of course, I guarantee it, you will be helping a ton of other people viewing this either live right now or in the future that are dealing with a similar problem. So not only will you be helping yourself, you will be helping dozens, if not hundreds of other people out there dealing with similar situations who are looking for some initial guidance, some initial advice on their situation, some help. And that's exactly what we're here to do. So please go ahead and post your questions right now. Let's line up a bunch of questions and I will get to them over the course of the segment. Now, we always start the segment with what at least we call on the radio show the case of the day. It's an opportunity to talk about a matter that came across my desk and that we've dealt with recently. And so I'll share with you an experience I had over the past couple of days. This is a gentleman I actually spoke with on Monday of this week, so just a couple of days ago. And this gentleman, unfortunately, lost his job. He was a relatively kind of long service employee, been with the same company for about 17 years. And he worked for one of the big five banks. I won't say exactly which bank, but he was working in the banking sector. And unfortunately, a number of the big banks in Canada, and we all know who they are, a good number of them are restructuring their operations. I think hundreds of people have been let go per bank. So there are, unfortunately, very unfortunately, thousands of employees out there who have been let go and are dealing with severance, dealing with coming to the realization that my job has come to an end. And a lot of these employees are long service employees. A lot of their jobs, they've come to an end. They have no idea what to do. They have no idea what next. And they're being offered this amount of money. And some of these offers are relatively substantial. So I'll speak, about the gentleman I spoke with on Monday. He was with the bank for 17 years in a management level position, not kind of senior management. He was a branch manager of one of the banks that he worked at, and he was offered, a significant severance package. He was offered a six-figure severance package, so not an insignificant amount of money for sure. And his initial impression of the offer was, oh, well, that's a lot of money. I think that sounds pretty reasonable to me. Let me just speak with an employment lawyer to make sure this is kind of all above board, all of the additional terms are okay. He was more concerned about kind of the legalese in the actual document than he was with the actual severance amount being offered. He kind of just assumed that that was a reasonable amount and that the bank was kind of doing what it was supposed to do from a severance point of view. So I spoke to this gentleman. We went through the document together. By the way, we did this completely free of charge. It was a free consultation. And we very quickly figured out that while the offer wasn't terrible, wasn't, completely unreasonable and the worst offer we've ever seen, based on this gentleman's 17 years of service, based on his position as branch manager, and he was in his late 50s. He is in his late 50s as an employee. This gentleman's looking at a severance package, I would say at least of something like 18 months of pay. It's not 18 weeks. It's 18 months. It's a year and a half's pay given his age, position, and years of service with the company. Those are the factors that are considered when assessing an employee's severance entitlements. The older you are, the longer you've been with the same company, the more senior your position is within that company, the more severance you're going to get. Again, this gentleman was looking at an 18-month severance package. And when we came to that conclusion and compared that to what he was actually offered, there was a huge difference. I mean, at least a $50,000 difference between what he was being offered and what he's actually owed. So we're not just talking about a couple of bucks here. We're not even just talking about a couple of $1,000s here. We're talking about $50,000 that he would be leaving on the table if he just blindly signed off on this severance offer and walked away. So the lesson here is, if you're in that unfortunate situation, it's obviously not easy. It's obviously extremely stressful, anxiety-inducing. It might be one of the worst kind of moments you go through in your life. If you've been let go from your job, do not sign off on a severance offer on the spot. Even if you think it's good, even if you think it's reasonable, even if you think it's generous, do not accept anything on the spot. You wouldn't sign any other contract on the spot. Why would you sign off on a severance offer without receiving professional advice from an employment lawyer? Give us a call. Again, a lot of these conversations, the vast majority of them are going to be completely free of charge, right? Make sure you're getting what you're actually owed. You don't want to leave tens of thousands of dollars on the table simply because you didn't get advice, simply because you assumed that what you were being offered by your employer was the correct amount, or you assumed that they were being fair and reasonable. I can tell you the majority of severance offers that we see fall well short of what they actually should be. And that's not, it shouldn't be an insult to the employee. It's not a personal attack on the employee when that happens. Employers, like in any other transaction that they are conducting, they are looking for good value from their point of view, from the employer's point of view, when letting an employee go. They're looking for a good deal, like any business would be. You have to treat yourself as a business. You have to treat your own rights, your own entitlements, your own protections as your own business, and make sure that you, from your personal point of view, as an employee who's been let go, that you are getting that fair, good deal for yourself as well. And ultimately, it's not whether the employer thinks an offer is good or not. It's what the law says about a severance offer. And our employment laws in Ontario, in Canada more generally, are quite favorable. They're quite protective of employees when it comes to severance. So a little food for thought there. Unfortunately, you don't have to deal with a termination ever. You or a family member or a friend or a colleague, you never have to deal with a severance offer. But if you do, if you do find yourself in that situation, or if you know of a family member or a friend or a colleague who's been let go from their job, give them a little nudge. Say, hey, you don't have to tell them to contact us. You don't have to tell them anything except for, hey, you might want to get advice from an employment lawyer in this situation. Don't sign on the spot, right? That's the basics. And that's the initial advice that anybody should be taking when they've been let go from their job. All right. With that out of the way, let us get to the questions, everyone. I see a couple of others have posted questions as well. That is excellent. Thank you so much. Again, I'll repeat this one last time. If you're just tuning in, my name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP. I'm a partner with the firm as well. This is your chance to get your employment questions answered. I don't care how big or small you think your issue is. Maybe you have a question about your pension. Maybe you have a question about, again, severance, temporary layoffs, terminations, changes to your employment. There are no bad questions when it comes to employment law. Or maybe you have a question about medical leaves of absence. Maybe you're sick, you're off of work, you're dealing with an illness, and you're concerned about your employment. Go ahead and post your question right now. We've got another 15 minutes to go. Plenty of time to post your question and to get it answered by yours truly. And without further ado, let's get to those questions. First in line for today was B on Facebook. B asks, my husband was terminated 3 months after taking a paternity leave. Red flag right there, of course. We have some conflict with his employer requesting temporary accommodations while finding childcare, and shortly after he was let go. He was there for 9 years, offered 16 weeks of pay. We think he was let go because of his leave. Is the offer low? Is there anything we could do? B, thanks for your message. I'm obviously sorry to hear you're dealing with that kind of situation. Not an easy one, certainly. You're, of course, um, you're a new parent, your husband, a new father, obviously dealing with all that comes with a baby at home. Having three children myself, I know exactly what that means. And on top of that, to make matters more complicated, more difficult, as if you're not tired enough, you're having to deal with, unfortunately, the loss of your job and just your employer giving you a hard time about all of that. So, a couple of points here. The most basic point is as follows. Number one, B, if your husband was let go in any way, shape, or form as a result of his having taken a paternity leave, or as a result of him asking the company to just play ball and help him figure out these childcare responsibilities moving forward. Right, and provide some accommodations. Maybe it's a different schedule. Maybe it's coming into work a little later than usual. Right, if your employer has let your husband, or if his employer has let his employment come to an end as a result of those reasons, that is discrimination under the Human Rights Code in Ontario. You cannot terminate an employee because they've asked or because they've taken a paternity leave or parental leave as a result of a childbirth. You cannot also terminate an employee because they have child care responsibilities. That is, again, a refusal to accommodate, and it's discrimination under the Human Rights Code in Ontario on the basis of family status. This is actually a little known area of protection under the law, but you can be discriminated against as a result of your family status. What that typically looks like is if you are a parent and for one reason or another you have to care for your child. Maybe they don't have daycare, or maybe they don't have access to before and after school daycare programs through your child's school, and you have to show up late to work because you have to drop your child off at school, or you have to leave work early to pick your child up after school, whatever the reason might be, or maybe your child's homesick and you need to stay home for that reason. If your employer terminates you or punishes you in any way as a result of you having those obligations, that is discrimination under the Human Rights Code. Your employer cannot do that. So that is point number one. B, if it is the case that that is indeed the reason why your husband was let go, that is a human rights claim. And your husband would be owed damages, compensation, financial compensation as a result of that reason for letting him go. On top of that, B, in case the company here isn't in hot water already, which it is very clearly, your husband was there for 9 years. He's been offered 16 weeks of pay. I obviously don't know your husband's age, B, and I don't know the position that he was in, but I can pretty much guarantee you already that for 9 years of service, 16 weeks of pay, which is actually a touch shy of 4 months, is not going to be enough severance when it comes to a 9-year employee. Listen, even if he's in his late 30s, early 40s, in that kind of range, and even if he's in a general kind of technical position or maybe laborer position, he's gonna likely be somewhere in the range of 1 month per year of service as his severance entitlements. If he's older, if he's in a management level position, and this applies to any employee, by the way, the older you are, the more senior your position is, the more severance you're going to get. If he's a 9-year manager, B, he might be looking at 12 months of pay, something in that range. So his severance entitlements are clearly more than the 16 weeks he was offered. On top of that, we've got a human rights issue. B, make sure your husband contacts us. Make sure we have a chat. Let's talk about the best way to move forward here. Listen, things don't have to get overly nasty or overly contentious. A lot of times in these situations, even in these situations where the employers clearly acted inappropriately, we can resolve these situations very easily and quite straightforwardly. So give us a call. Let's have a chat and get you on the way to resolving that problem and alleviating that stress of your former workplace. All right. Thank you for the question. That's an excellent one. Let's keep it moving, everyone. Sir S on YouTube asks, what rights do you have if your employer chooses the branch you work at? Do you have to accept a location transfer? I've worked here for 13 years. Sir S, great question. If you've worked at one location for 13 years, and you've never moved before, or maybe you've moved, but it's been very, very kind of locally, and you're now being asked to change work location, and the change, here's where, the most important piece, Sir S, and the change is a significant one. Listen, if you're being asked to drive an extra 5 or 10 minutes, right, to another branch, another location, that's not going to be a major change to your employment. Sir S, the employer likely has the right to ask you to do that because, again, nothing significant is really changing except for maybe a bit of a longer drive. But if the branch is 45 minutes away, right, and you're now adding an hour or an hour and a half to your commute every single day, well, that's patently unreasonable. That's clearly unreasonable. You have a right to say no in the circumstance. You have the right to say, no, no, thank you. I'm going to stay where I am, and I'd prefer to work here. If your employer tries to force that change on you, that is what we call a constructive dismissal. A constructive dismissal is basically a breach of contract. It's when your employer tries to change your employment terms in such a significant way that you would be allowed to say, no, I'm not accepting that. And if you force it on me, I'm going to consider myself terminated and obtain my severance entitlements. So you might have the right to ask for severance, Sir S, if your employer is asking you to accept a significant or substantial change to the terms of your employment. When it comes to a location change, again, the distance of the new location needs to be significant enough in order to trigger that constructive dismissal. So it depends on where this new branch is, SRS, and how it affects your commute to work. If it's a significant change, you've got rights and protections. If it's a very minor change, you may just want to bite the bullet and accept that change. Before, Sir S, you say yay or nay to your employer, right? And hopefully you haven't already. Hopefully you haven't signed anything, for example. But before you say anything to your employer as to whether you're in agreement or not, give us a call at the office. Let's have a chat off air and figure out exactly the circumstances you're in, exactly what options and rights you have, and develop a game plan moving forward. You don't want to receive advice after the fact. You don't want to take a decision. That decision might be the wrong one, and then you have to speak to an employment lawyer. Before something happens at work, make sure you get the advice, strategize with one of our employment lawyers, figure out what the game plan moving forward looks like so that you are protected moving forward with your career. All right, Roland is up next. Roland says or asks, can I go to the Ministry of Labor if I was not paid my bonus for working the season? It wasn't in my contract, but I know I'm entitled to it and they know it. I have recordings to prove it. Roland, I am not a huge fan, and this is not my personal opinion. It's simply the way the law works. I'm not a big fan of going to the Ministry of Labor when it comes to these kinds of issues. The reason why is the Ministry of Labor can only enforce an employee's minimum entitlements. And so if you either resign from your employment or maybe you've been let go from your job and you're having to kind of argue for the bonus, or maybe you're even still working there and there's a kind of question mark as to whether you're owed the bonus or not, the Ministry of Labor can only do so much. And it's likely that they will not be able to assist you here. If it was something, Roland, like vacation pay, or maybe hours of work, right? Maybe you banked a couple of hours, or maybe they're not paying your correct hourly rate. Basic stuff like that, I have no problems actually with an employee going to the Ministry of Labor. That's actually what they're quite good at. But when it comes to bonus, when it comes to severance, when it comes to those kinds of significant components of an employee's compensation, it's the wrong place to go. They're not going to be able to help you, or alternatively, they'll make the wrong decision, and then you're in trouble. Speak to an employment lawyer first. Let's get you some advice. Let's make sure, what's the deal with this bonus? You say you have evidence. What's that evidence? Why haven't they paid it? What's their position? Let's have a chat about that. And I guarantee you an employment lawyer can help much more effectively than the Ministry of Labor can. Jason J asks, what is the difference between LTD and PWD process? Jason, I'm not sure what PWD process means. If you want to quickly type it in the chat, if that's some sort of workers' compensation process or workers' compensation a kind of income or disability benefit, listen, disability insurance can apply to any injuries or any illnesses or health concerns, regardless of whether they happen in the workplace or outside of it. And so you can be on short-term or long-term disability benefits if you were, for example, diagnosed with cancer, right? And that's completely unrelated to your work, but you're medically unable to work for that reason. If you have disability benefits coverage, you can apply for those disability benefits, regardless of whether it actually happened at work or not. Workers' compensation is for injuries or illnesses that happen in the workplace or as a result of the workplace. That's when, at least in Ontario, you would apply for something called WSIB. And that is effectively workers' compensation. But again, those are specifically related to workplace injuries. Selena is up next, and unfortunately, we'll do these rapid fire, everyone, only because we've got only a few minutes left, but I do want to get to all of them. Selena on Facebook asks, I was laid off after only 2 months. This would be the probation period. So am I owed anything? Good question, Selena. It depends on your contract. I imagine you signed something when you started working at the company. Have a look at that. If there is a probationary period clause or provision in the contract that says you're on probation for 3 months, if we let you go during that period, we don't owe you any termination or severance pay. If that's the case, it's likely you might not be owed anything. Probationary periods are legal, Selena, but they have to be written into a contract. If there is no contract of employment, or if your contract of employment doesn't say anything about probation, maybe it was just told to you verbally, then there is no probationary period. You can't just kind of create or assume a probationary period. It needs to be a written term of employment. If there's no such written term of employment, Selena, even as a 2-month employee, you're going to be owed severance. Your severance may still be significant as a 2-month employee. It might be several weeks, if not months, potentially. And I'm not kidding there. I'm not exaggerating. Short service employees can be owed significant severance despite the fact that they weren't with the company for a very long time. All right, Liz up next asks, HR requested a doctor's note for my accommodation for disability. How much info need be given? Very good question. Liz follows up, I started by asking HR, need a full and detailed job description to give doctors for their input. What else could I do? Liz, listen, it's okay for an employer to ask for a doctor's note about an accommodation request. Keep in mind, your doctor is kind of the rule maker here in terms of it's not your personal opinion that matters as to accommodations. It's not even the employer's personal opinion that matters. It's what your doctor says. So speak to your doctor. Your doctor needs to put in writing, on paper, a game plan as to what exactly you can and can't do. I don't want to exaggerate and say that it needs to go into every single detail of every single minute of your workday, but it needs to be pretty specific. So if your job involves some sort of manual labor, right, how much could you lift or not lift, right? If it's a lot of office work and maybe you need to get up every so often, how much time do you need to take breaks every so often or not? Detail, but from your doctor. Liz, they don't need to necessarily know what the diagnosis is, right? They don't need to know necessarily how long these accommodations might last for, although that might be helpful, but they need to know what can you do and what can't you do, and it needs to come from your doctor. That is the way to do it. All right, Helen asks, we're going to go a couple of more minutes here, guys. I hope that's okay. Please, these questions might be helpful to lots of you, so keep tuning in. Helen is up next. Helen is a regular viewer of the show, so thanks for asking the question, Helen. My employer terminated after reporting bullying. What law does it violate? What remedy can be awarded from Supreme Court? What is the law basis for intentionally inflicting anguish and remedy? So, Helen, the law here is, well, if you're in Ontario, Helen, there are a couple of pieces of legislation. So, number one, the Employment Standards Act in Ontario makes it illegal for an employer to punish an employee for raising concerns in the workplace. For example, about bullying or harassment in the workplace. It's what we call a reprisal. So reprisal is illegal in Ontario. And again, it would fall under the Employment Standards Act. It would also fall under a piece of legislation called the Occupational Health and Safety Act. Under the Occupational Health and Safety Act in Ontario, an employer has to protect employees, has to keep them safe and healthy, hence the name of the legislation, but protect them from harassment in the workplace. Those are the pieces of legislation those kinds of situations would fall under. All right. P. Chan asks, I work for a major bank. They purchased another bank clients. I work in a Visa call center now. They want me to make those MasterCard calls. There is a special call center, P. Chan continues, which was set up for those calls. Now they want me to take those calls, which increases my workload and stress and impacts my performance. Do I have to accept this? Excellent question, P. Chan. So again, this speaks to changes to your employment. Now, keep in mind there is a threshold here and there is a spectrum here. If your employer is asking you to take on some more work, right, and it's a little more work, but not doubling your workload or not something that's exaggerated. Listen, your employer has some discretion to change your terms of employment to a certain degree, right? It's okay if they ask you to take on a little more or do something slightly different than what you were previously doing or what you're currently doing, right? Employment terms are not set in stone forever. There has to be some degree of flexibility there. But if it's the case, P. Chan, that literally this new work is doubling your workload, right? And they're not compensating you for it. You're not getting more pay. You're not getting more bonus. In fact, it might be affecting your performance because you have so much to do. That is a problem, right? But it's the spectrum, right? If it's going to be a major change to your employment, then I think you could take issue with it. Have a conversation with your employer. If they're not willing to back down, give us a call at the office. We can discuss a strategy moving forward if that's the case. But it's whether the change is significant or not. And of course, what is significant or not significant, there'll be a spectrum there, there'll be a range there, and there might be even kind of a gray zone there. So be careful of that. Last but not least, I want to make sure I answered all questions today. So we're going a little over time. Mary Lou on YouTube asks, last question for the segment. I was coded as LOA, leave of absence, while on gradual return from disability. I lost position as full-time. I reapply for disability, was denied of this. Is this a wrongful dismissal? Mary Lou, it potentially is. If you are looking to return back to work, you have the right, Mary Lou, to return back to the same terms of employment you left. If you were working full-time before your medical leave, right, but now you're ready to come back and your employer says, oh, sorry, we don't have that full-time position available, you have to accept something else, or just stay on a medical leave until we're ready. That's not good enough. Your employer has to have you back to work, not only back to work, but to the same terms of employment you left. So that could be a constructive dismissal, Mary Lou. It's been a theme of the show today, and I'm glad lots of you have asked these kinds of questions. If your employer is not bringing you back to work after a medical leave on the same terms of employment you left, that is a massive red flag. Don't just assume your employer can bring you back to work part-time or in a different position or a different pay. That could be a constructive dismissal, in which case you would be owed severance. Mary Lou, give us a call at the office. Send us an email at help@employmentlawyer.ca. You have rights and options in the circumstances. Do not just let this go. Thank you all so much for tuning in. It's been an excellent live stream today. Don't be shy to tune in next time if you haven't gotten your question answered or if you're curious and weren't able to ask today. Until then, wishing you all the best for the rest of the week. Take care, everyone. So long.